Sexual harassment. But what really is and what is not sexual harassment? Harassment of any kind is bothersome, demeaning, irritating, and annoying behavior. Sexual harassment is specifically harassment of a sexual nature. Disrespectful or offensive sexual behavior by administrators, staffs, or clients is inappropriate, and in some cases may be abuse of authority. The involved parties can be men or women, supervisors, subordinates, or peers. We all suffer when abusive and demeaning behavior is tolerated in our workplaces. To eliminate sexual harassment, we need to understand it, the law quid pro quo, and the hostile work environment. Sexual harassment law in the United States has developed over the past 4 decades. Sexual harassment is a form of employment discrimination prohibited under Title VII of the Civil Rights Act of 1964, as amended. The law describes 2 different forms of sexual harassment, quid pro quo and hostile work environment. The examples of quid pro quo: have sex with me and you will get a raise, or have sex with me or you won't get a raise. Quid pro quo is usually more severe and occurs less frequently than hostile work environments. Sexual harassment. Quid pro quo occurs when employment or academic decisions and conditions are based upon whether the targeted individual is willing to grant sexual favors. Hiring, promotions, salary increases, shift or work assignments, and performance expectations are some of the working benefits that can be made conditional on sexual favors. In the academic setting, quid pro quo occurs when grades, housing, professional evaluations, recommendations, or other academic decisions or benefits are conditioned on sexual favors. Quid pro quo examples: Tom offers his assistant Nancy a ride home following an after-hours function. At a residence, he attempts to kiss and sexually fondle her while urging her to invite him in. She resists his advances and tells him she is offended and angered by his behavior. Tom leaves and does not mention the incident again, but during the following weeks, he reorganizes the department and reassigns Nancy to a less responsible clerical position. This situation is a typical example of quid pro quo sexual harassment. The law. Hostile environment. Hostile environment. A hostile environment is one in which unwelcome conduct of a sexual nature creates an intimidating, offensive, or disruptive work or academic environment for some members of the campus community. Examples of this conduct may include sexually explicit talk or emails, sexually provocative images, comments on physical attributes, or inappropriate touching. Good humor. Most of us love a good laugh. Humor can relieve tension and energize, but teasing and sarcasm are high-risk ways of communicating. Does this mean that all fun is out of the order on campus? Absolutely not. But if the fun is at the expense of another person or persons, it is risky. It was just a joke is not an excuse for sexual harassment. People often have such different perspectives on behaviors that it is easy to offend someone through ill-considered attempts at humor, teasing, or sarcasm. Remember that the only impact and not the intent matters in determining if a reasonable person would consider the behavior sexual harassment. Before taking dangerous risks, make certain that your behavior, whether in person, by phone, or via email, is welcome. A careless mistake may become very costly to the respect others have for you and to your financial and job security or status.